Welcome everyone. Thank you so much for joining us today from different parts of the world for this online public lecture, jointly organized by Singapore International Arbitration Center, SIAC, and Chulalongkorn University Faculty of Law. We are very pleased to be informed by the organizer that we have an amazing turnout for today's lecture. So thank you very much once again for your participation. I'm Dr. Thidarat Sinpapiromsuk, law lecturer at Chulalongkorn University, and also the arbitrator based in Thailand. It's a real honor for me to be here with you today as your MC and moderators for this very interesting special lecture on due process in international arbitrations. As one arbitrator put it, due process may be hard to define, but it's easier to appreciate when it's being denied. Due process is one of the most important topics in international arbitration. Given that due process allegations against the tribunal has been increasing over the years, in other words, there has been a notable increase in the number of the parties who have sought to invoke due process as a sort rather than adjudicative, the words that borrow from Professor Lucy Reed. Therefore, today, due process has become the real test to the arbitral tribunal. And the abuse of due process had led to the phenomena of the due process paranoia, with its potential to undermine the efficiency of arbitration proceedings. In this lecture, you will be introduced to the concept of due process paranoia, including, among others, the illustrations of due process issues that commonly arise in international arbitration. Whether such challenges are exacerbated by the ongoing COVID-19 pandemic, practical approaches adopted by the tribunal in dealing with the due process concerns, as well as a comparative approach on how national courts have dealt with these issues. Today, we are very fortunate and privileged to have with us a distinguished speaker, Mr. Chong Yi Liang, who is the Deputy Chairman of the Board of Directors for the SIAC, and also on the panel of arbitrators for the SIAC. He is also a partner at Allen & Singapore, where he is the co-head of the firm International Arbitration Practice, and also the head of the restructuring and insolvency practice. Yi Liang is recognized as a leading international dispute resolution specialist, where he has been involved in numerous arbitrations administered by or in accordance with the rules of various institutions. He specializes in energy, oil and gas, power, and infrastructure projects. And he also recognized as a senior accredited specialist in building and construction law by the Singapore Academy of Law as well. Today, we are going to start with a presentation by Yi Liang. And if you wish to raise any questions or share your views, please feel free to use the Q&A box at the bottom of your screen. We welcome your contribution, and we'll try our best to go through them at the end of the presentation. So thank you in advance for your contribution. Without further ado, I'm absolutely delighted to invite Yi Liang to deliver this public lecture titled Due Process in International Arbitration. So now over to you, Yi Liang. Thank you.
Thanks very much, Kun Thidarat, for that very kind introduction. Let me share screen. Of course, I have a few PowerPoint presentation that I prepared. Okay, I believe everyone can see my PowerPoint presentation. Today's I'm going to talk starting off with the concept of due process, which is a concept that I believe lawyers and particularly dispute lawyers are familiar with, and particularly how due process is actually very important in international arbitration, and how in fact it is applied in international arbitration, and what are the consequences of failing to respect due process principles. And then I will go on to talk about this phenomenon that has happened in the international arbitration world called the due process paranoia. Sometimes, not sometimes, I think most of the time, there's always a danger of too much of good things. And we will see this situation where due process has been used to disrupt arbitration. And finally, then I will talk a bit about judicial perspective, particularly from a Singapore point of view. How did Singapore courts deal with this phenomenon and how they achieved a good balancing act between due process and efficiency in arbitration. Okay, let's start off with the concept of due process. Now, the concept of due process is really the cornerstone of the rule of law. It guarantees the important procedural fairness in dispute resolution mechanism. And therefore, it is actually applied to protect and promote fair process according to which party substantive rights are determined. It is very important because it is meant to protect people and ensure people are not deprived of their property of other rights without fair opportunity to defend themselves before neutral judges. And due process also serves as a shield of fundamental procedural rights before deprivation of substantive rights. So ultimately, fairness is crucial for the legitimacy and credibility of any legal proceedings, including international arbitration. Now, this is just a quote I've obtained from a landmark Court of Appeal decision in Singapore in the case of China Machine New Energy and Jaguar Energy Guatemala, a case that we will talk about a bit more later down the lecture. But the Court of Appeal at the beginning of the judgment actually described the concept of due process as follows. They say that the concept of due process encompasses a basic guarantee of procedural fairness in legal proceedings. So it requires each party be given, among other things, appropriate notice of the proceedings and of the case it has to meet, as well as a fair opportunity to prepare and present its case before a neutral and unbiased decision maker. These are basic procedural safeguards which are applied in order to ensure the fairness of the proceedings by which the party's substantive rights are disposed of. In short, due process concerned with ensuring fair process, and this is a matter of critical importance because fairness of the process is integral to its legitimacy in the eyes of the parties who submit themselves to it. So, as you can see from the description, due process, or what in international arbitration circle referred to as fundamental procedural fairness, can be broken down into four components. The first is a party must be given appropriate notice of the case it has to meet, and this is important. Obviously, if someone is making a claim or are being claimed against, they must know the claim that's being made against them or the defense that has been put up against their claim. So notice is actually very important. And obviously, one remember the time where communication was not so prevalent as it is now. I think nowadays we communicate with each other over various way, through email, through WhatsApp messages, through phone messages, through all sorts of messages. So it is very unusual in the current circumstances to say that you have not had notice of a case that you have to meet. Whereas in the old days where communications are not as prevalent as today, this actually takes a more important note in the concept of due process. Well, the second point about due process is that a party must be given full or reasonable opportunity to present his case and respond to the case against it. So once you have notice of it, you must be given an opportunity to present your case. Now, there you can see that there is these two concepts: full opportunity or reasonable opportunity. The question is there a difference between the two, between full and reasonable? Well, that's something that we will talk about as well later down the lecture. The third concept is actually before a neutral and unbiased tribunal, and that, of course, is a very important consideration. I'm not going to talk so much about this because this topic alone on its own merits a lecture on its own, but I'm going to focus more in today's lecture on the procedural fairness in terms of opportunity to present case and to respond and to have notice of the case. And finally, there is the component of being treated with equality. That means that parties must be treated equally in terms of opportunity to present their case, opportunity to introduce evidence, opportunity to submit before the tribunal. So those are the four fundamental components of due process. Now, these are all the due process that I've described is obviously very important generally in dispute resolution processes, in court processes, in process adjudication processes before any tribunal. But it has a significant importance in international arbitration. Why do I say that? Because first of all, international arbitration results in binding decisions against parties, which are generally enforceable in most parts of the world pursuant to New York Convention. So now I believe New York Convention signatories have increased to more than 160 countries in the world, which basically covered most of the civilized world. So to have an award that is enforceable against you in most of the world, I think it is important to make sure that to ensure that due process is met in arriving at the award. Effectively, arbitrators are performing adjudicative functions. So it is not difficult to understand that due process have always been considered as an integral part of international arbitration process. There's also another reason why due process is so important in international arbitration. There is, in general, no appeal process in international arbitration. What does that mean? That simply means that unlike a court proceedings, where if you lose at the first instance, there's usually an ability to appeal to a higher court, whether it's a court of appeal or Supreme Court or a federal court, where you have a chance to re-argue your case on the merits and persuade the appellate court that the lower court is wrong. Now, this appeal process is not available in international arbitration. The concept is being that arbitral process is final. There is a finality to it, and parties have agreed not to appeal against it. So if the arbitrator, or not if, when the arbitrator issue an award, the parties take the award as it is, for good or for bad. If the arbitrators get it wrong, too bad, you can't appeal. So it is very important to ensure that there is due process in arriving at the award, and not only that, there are limited grounds to challenge the award or to apply to set aside the award or to resist enforcement. And one of these grounds is actually the violation of parties' due process rights. So you can see that due process is actually occupy a central plank in international arbitration. Now, in arbitration, the tribunal is a master of its own procedures. What does that mean? Usually, if you are involved in a court litigation, there are detailed rules in the court rules to tell you how to plead your case, how to present your evidence, how to make an application for discovery, how to make an application for interrogatories, how to apply for further and better particulars, and all these essential matters. Well, not so in arbitration, because generally most arbitration rules are drafted in a very flexible manner, which means that tribunals are usually allowed to come up with their own procedures and they'll dictate their own timetable in terms of how the arbitral process is supposed to be conducted. And that gives the tribunal a lot of flexibility, a lot of leeway, but also a lot of power to decide how to conduct an arbitration. And the requirement of due process is essentially a check and balance of this wide autonomy of the tribunal. A good summary of this relationship actually can be found in Article 15.1 of the 1976 UNCITRAL arbitration rules. And it says there that subject to these rules, the arbitral tribunal may conduct the arbitration in such manner as they consider appropriate, provided parties are treated with equality, and that at any stage of the proceedings, each party is given a full opportunity of presenting its case. So here you can see parties must be treated with equality. You remember that was one of the components of due process. And then at any stage of the proceedings, they say that each party is given a full opportunity of presenting his case. That means they must have a full opportunity of presenting his case. In 2010, UNSTRAL provided a new version of their rules. They amended Article 15.1. Now it's the new Article 17.1. And you can see there that they have made certain amendments, which are highlighted in bold in these slides. And you can see that the amendment, the first amendment there says that parties are treated with equality and that at an appropriate stage of the proceedings. Compare that to 15 in 1976. It says that at any stage of the proceeding. So instead of any stage, they change it to at an appropriate stage. Okay. And the next amendment is actually says that each party is given a reasonable opportunity of presenting, as opposed to the earlier version where they say each party is given a full opportunity of presenting his case. And then finally, there is a rider in the new rules where it says that the arbitral tribunal in exercising its discretion shall conduct proceedings so as to avoid unnecessary delay and expense and to provide a fair and efficient process for resolving the parties' dispute. Now, how did this come along, and why is that the UNSTRAL committee thought that it is necessary to make these changes? I will elaborate more on this when we talk about due process paranoia. Okay. So another area where due process is actually enshrined in international arbitration is actually Article 18 of the model law, where it says there that equal treatment of parties shall be treated with equality, and each party shall be given a full opportunity of presenting his case. Now, model law countries will have this. Singapore adopted model law, and this has a force of law in Singapore. And in the commentary on draft text or model law, there actually says there that paragraph 3, which is this paragraph at the top that I have shown, adopts basic notion of fairness in requiring that parties will be treated with equality and each party be given full opportunity of presenting his case. Again, the word is used is full opportunity. Another area where due process is given recognition in international arbitration is in the New York Convention. And it says there that an award may be refused enforcement on due process ground. Effectively, it says there that if a party is not given proper notice, you remember that it is again another component of due process of the appointment of the arbitrator or of the arbitration proceedings, or was otherwise unable to present his case. Okay, so the international award can be refused enforcement if a party is unable to present his case. Similarly, in model law, you can see that in Article 34, which is the article for setting aside an award. An award can be set aside if a party is not given proper notice of the appointment of an arbitrator of the arbitral proceedings, or was again otherwise unable to present his case. The same formula is used. And Article 36 deals with recognition and enforcement. And similarly, an award can be refused recognition or enforcement if no proper notice was given or a party was otherwise unable to present his case. And in Singapore, we have the International Arbitration Act. So in addition to the model law, which Singapore has adopted as its law, Section 24F of the IAA also said that court can set aside an award if there's been a breach of rules of natural justice, which is another way of saying that when there's a breach of due process. Similarly, enforcement can be refused when no proper notice was given or party was unable to present his case. So one can see that, well, due process is really entrenched and enshrined in international arbitration. So it can't be bad to have too much due process, right? Well, I think it's always possible to have too much of a good thing. Not saying that there are too much of equality or too much of parties being given opportunity to present their case, but I think parties have found way and very creative counsel have found way to use due process to advance their client case and to, where necessary and to their client's advantage, disrupt international arbitration. Let's see how it's done. Well, first of all, as I've earlier mentioned, I think all arbitration legislation and institutional rules recognize that tribunal has wide discretion to conduct proceedings in a manner they deem fit. I have earlier referred to 2 articles in the UNCITRAL arbitration rules. And indeed, arbitrators have often been referred to as master of their own procedures. That means they dictate and they decide how to conduct an arbitration. But it is important to understand that this broad discretion is not to be exercised in vacuum. It simply means that arbitrators are not allowed to exercise in a capricious manner, in an arbitrary manner. They have to exercise the discretion in discharging their duties. And what is their duties? First of all, their duties is to provide a fair, efficient, and expeditious means of dispute resolution. That's one duty. And obviously, the other duty is due process. So they have to reconcile principles of due process on the one hand and efficiency on the other. Okay, this balancing act can be difficult. Why do I say that? Well, think about it. Due process says that you must give parties a full opportunity to present their case. So taking to the extreme, parties can say that I want to be able to put in all the evidence that I have. I want to have unlimited right to submit to the tribunal. I want to have unlimited time to make my oral submissions. And on the other hand, the tribunal have to ensure that the proceedings is proceeding with due speed, because parties are not into our international arbitration for a slow process. They want their dispute to be resolved speedily. They also want their dispute to be resolved in an affordable manner. That means that costs got to be reasonable. So how do you balance the both? And this is where the problem starts. Parties have, or counsel rather, very clever counsel, has come up with tactics to attack tribunals and to attack arbitration proceedings, particularly parties that are losing their case. They want to achieve certain things by delaying the proceedings, by prolonging it, by making it very difficult for the other party to proceed, and they use due process. They what we call, they abuse and manipulate due process. They want to have time, a lot of time to make their submissions. They want to make their submissions not in accordance with the procedural timetable that have been given by the tribunal. They make repeated requests to introduce evidence even after the ordered timeline. And they employ this tactic as a sword to undermine the legitimacy of the proceedings. So instead of using due process, which is meant to be a shield for the parties to prevent them from being treated unfairly, counsel are using it as a sword to threaten the legitimacy and the credibility of the proceedings. And these circumstances pose unique challenges to arbitrators, which must be able to discern whether these requests are legitimate procedural requests, or they are no more than guerrilla tactics to disrupt the proceedings. In fact, in 2015, in the Queen Mary and White and Case survey on international arbitration, they have coined a phrase called due process paranoia. And what is due process paranoia? Due process paranoia is a perceived reluctance by tribunal to act decisively in certain situations for fear of the award being challenged on the basis of a party not having a chance to present its case fully. What does that mean? That means that actually in recent times, in the last maybe 10 to 15 years, tribunal has been being overly indulgent to parties. When parties request for more time to put in their submissions, when parties request at the last minute to put in more evidence, when parties want to have longer time to put in their submissions, tribunals have tend to indulge and to allow parties to do that. And one would ask, why did the tribunal adopt this stance? The reason is because the tribunal is worried that if they do not accede to this request, the party would then run to court and complain to the court and say that their right to due process have been compromised. And therefore, the award should be set aside. And therefore, the tribunal is erring on the side of caution in dealing with these procedural applications to ensure that parties cannot complain about the violation of their due process rights. So, tribunals suffering from due process may offer excessive willingness to accommodate parties' procedural requests, notwithstanding the actual merits of the request. And then they exhibit inclination to make case management decisions in favor of due process, often prejudicing time and cost effectiveness of the proceedings. Obviously, right, if a tribunal allow this kind of request, for example, a last-minute request to put in more evidence at the merit hearing, then the hearing will have to be vacated, or the hearing will have to be adjourned, or the hearing will have to be part heard, and then more time will have to be dedicated to have another hearing to hear this new evidence. If a party makes the application for more time to put in the submissions, then the timeline will be prolonged and more time will be taken. And therefore, the whole arbitral proceedings will be prolonged and will be delayed. And as a result of that, more costs will also be incurred because parties will have to deal with this additional evidence, additional submissions, and more time taken to finish the arbitral proceedings. And in fact, that is one of the major complaints of users of international arbitrations. They say that international arbitrations have become too cumbersome, taking too long, now even longer than court proceedings, and has resulted in exorbitant costs because parties have to spend a lot more time dealing with these kind of issues. So the common perception that fuels this paranoia is this, that the tribunal is worried that a violation of this due process right will give the losing party an opportunity to set aside or resist enforcement. So their approach is to ring-fence this and to make sure that parties do not have any ground to complain. But taking excessive precaution, okay, well, is in the arbitrator's interest because they do not want their reputation to be besmirched. You know, arbitrators do not want their award to be set aside. They do not want to be accused of violating parties' due process. So you can see that these are some of the situations that have a reason that usually put arbitrators on the back foot. You know, deadline extension requests, unsolicited submissions by the party, submission of documents and evidence after order deadline, late introductions of claim, requests for rescheduling of evidence hearing because clients are not available, witnesses are not available, counsel are not available. And that creates a lot of difficulty. Now, the question one asks is that, is the fear of the arbitrator justified? Are they justified in fearing that, you know, just because they do not agree to this extension, to this request, the award could be set aside? Empirical evidence have shown that it's very rare for award to be set aside on due process ground. Okay, this is empirical evidence of judgment that have been analyzed across various countries. And indeed, a 2016 study found that court across various jurisdictions rarely vacate awards on ground of due process. And courts generally has also made it plain that the threshold of finding a breach of natural justice is very high. and court will be slow to find such threshold has been crossed. Nevertheless, because of the attitude of tribunals in dealing with this due process paranoia, and these guerrilla tactics that have been employed by various counsels to achieve their clients' collateral desire in international arbitration, there may be prejudice that have been caused generally to international arbitration and to the reputation of international arbitration. Like I say, delay have been caused, costs have gone up, and there have been instances where tribunal could be intimidated because tribunals are concerned that the award could be set aside. It may also result in unconscious bias of the tribunal. What do I mean by unconscious bias of the tribunal? Tribunals sometimes can get irritated with the application, with the counsel who make all these requests and application, and therefore might develop a bias against them or their client. Alternatively, the tribunal may be intimidated to such an extent that they lean in favor of these parties who make the repeated request to try to ensure that the award is a set-aside proof. All this essentially undermine the integrity of the international arbitration proceedings. So for the next part of my lecture, I just like to examine how in Singapore the court has dealt with this international this due process paranoia that's come across. And the first case that I'd like to talk about is the case that I've just mentioned to you all, the China Machine and Jaguar Energy case. That is a landmark case of the Singapore Court of Appeal, because there was a first instance where the Court of Appeal has the opportunity to deal with this on a holistic level. And that this is what they say. Two key principles have been laid down by the Court of Appeal. And they say, first of all, the overarching inquiry should be whether the tribunal conducted proceedings in a fair manner. In doing so, the court should ask itself if what the tribunal did or decided not to do falls within the range of what a reasonable and fair-minded tribunal in those circumstances might have done. So yes, fair manner. Then you will ask, what do you mean by a fair manner? The court said, well, the test is this, right? The test is whether the decision of the tribunal falls within the range, is a range of what a reasonable and fair-minded tribunal in those circumstances might have done. So it's not a question of whether the decision is right or the decision is wrong. Let's say, for example, a tribunal decided that and a request to put in evidence on the last day of the hearing, of the merit hearing, should not be allowed because it would disrupt the proceedings. The question, if this award is being challenged, and if a party applied to court to set aside the award because they were not allowed to put in evidence on the last day of the merit hearing, the court will ask itself whether that decision fall within the range of what a reasonable and fair-minded tribunal in those circumstances might have done. It's not whether the decision is right. The court will not look at the decision and say, oh, the tribunal should have allowed evidence to come in, or the tribunal is correct in not allowing. That's not the question. Okay, it's not a question of whether it's right or wrong. And the court should not be putting itself in the tribunal's position. The court is not there to answer the question, but the court is there to look at whether the decision is a reasonable one. If it is reasonable and is within the range, then the court will not interfere, even though the court may not agree with the decision. So that is the important distinction. The second key principles that the Court of Appeal has come up with is this, that in undertaking this exercise, the court will only assess a tribunal's decision based on the information which was known to it. That means that the court will only look at the decision on the basis of information that have been made known to the tribunal at that time. The court will not look at extraneous information or information that have come about later. Let's say, for example, a party applied to set aside, and then they introduce new evidence to show why the decision was a violation of their due process. The court will say, I will not look at it because it is unfair to the tribunal the tribunal did not have that information at that time when they make the decision. So the court will not look at any new information. They will only look at the information which was available at that time. And it says that the court should accord a margin of deference regarding matter of procedures. That means that they should give the benefit of doubt to the tribunal. Okay? And then the court also make a very important observations on the requirement of the full opportunity under Article 18 of the model law. If you remember, just now, Article 18 says full opportunity. Now, Article 15.1 of the UNCITRAL arbitration rule says full opportunity, but Article 17.1 of the 2010 UNCITRAL arbitration rule says a reasonable opportunity. And there are other arbitration rules that say a reasonable opportunity. There are some arbitration rules that say full opportunity. Well, in practical terms, is there a difference? This is what the Court of Appeal said. He said that a party right to be heard was a fundamental rule of natural justice. The court observed that model law right to a full opportunity of presenting one's case was not an unlimited one and was impliedly limited by considerations of reasonableness and fairness. Okay, so although it says full opportunity, it has to be limited by consideration of reasonableness and fairness. It is not unlimited. What does that mean? That means that even though you have a right to full opportunity, it doesn't mean that a party has got unlimited right to put in evidence. It doesn't mean that a party have unlimited rights to make submissions. It doesn't mean that parties have unlimited rights to have oral time or to have time to make oral submissions to the tribunal. It has to be reasonable and it has to be fair. Fair meaning looking at the context of the case. That's why it's a factual inquiry and it is very fact sensitive. So these are the important principles that can be distilled from China Machine. It says that right to be heard is not uncurtailed or unlimited right. There's a limitation on its rights to prevent unscrupulous parties from abusing their right. Remember the due process paranoia? What the court effectively saying to the tribunal is that don't be worried. You should not sacrifice all efficiency in order to accommodate parties' procedural requests. Concern of due process must be balanced against the requirement of expediency and efficiency. Okay, and the court effectively tell the tribunal, if you do that, and if you do what fair-minded and reasonable tribunal will do, I will have your back and I will not interfere with your decision. That's what the Court of Appeal said. Okay, now those are the principles. It's still, of course, in general terms, because like they say, it's very fact sensitive. So let's have a look at 3 cases in Singapore as to how it was applied and how challenges were dealt with. Of course, the first case that we will look at should be China Machine. This is a case we've dealt with construction of a power plant in Guatemala. And there was a dispute between the contractor who was employed to construct the power plant and the owner who employed the contractor to construct the power plant. And there was an EPC contract that was entered into. And the EPC contract was terminated. And obviously dispute arose and arbitration was commenced with claims by the owner for inter alia cost of completing the plant. Obviously the plant was half complete and the owner terminated the contractor and then have to employ replacement contractors to complete the plant. Now in the arbitration proceedings, there were substantive issues relating to how much those completion costs were. And the focus was on production of contracts, invoices, and other supporting documents evidencing cost of completion. That means these are contracts with the replacement contractors, invoices issued by the replacement contractors, and then there are other documents. And during the arbitration, there were procedural issues that arose in relation to the discovery of documents. The first issue was the owner did not want to disclose certain sensitive documents identifying the replacement contractors to complete the plan because they say that they are worried that contractors may interfere with the works, may interfere with the replacement contractors, may stop or prevent the replacement contractors from completing the works. Now, they introduced evidence of that, and the tribunal was convinced, or rather the tribunal was persuaded that there were risks, that there could be interference, and therefore they ordered that the sensitive documents be disclosed on an attorney eyes only basis, what we call AEO order. What does that mean? That means that documents can be disclosed, but only the lawyers can look at it. The employees and representatives of the contractor cannot look at it. This is to prevent information from flowing to the contractors and from prevent them from interfering with the replacement contractor's work. Then less than a month later, this AEO order was replaced by a redaction ruling. That means that disclosure can be made to the contractor's employees, but with information on identity of the replacement contractors redacted. And this was later modified by another procedural ruling that say that contractor with value of less than $100,000 need not be redacted. And then half a year later, all the sensitive documents were ordered to be disclosed in full. Presumably by then, the work has been completed and there was no danger of interference. The second complaint was that the contractors say that their access to their project documents on work they had carried out before they were terminated was restricted because it was forced to leave site upon termination. And finally, the third complaint was that the work to complete was ongoing and in parallel with the arbitration proceedings. Therefore, disclosure of these documents had to be made on a rolling basis because they were being created as the arbitration was proceeding. And the contractor complained that the tribunal failed to put a stop to this continuous disclosure. And it went on till quite far into the proceedings, and they didn't have enough time to prepare. And they also complained that the documents were disclosed in a disorganized or haphazard manner. And in the end, the tribunal found for the owner and ordered the contractor to pay for the replacement contractor's cost. And the contractor applied to set aside the award on the basis that the tribunal mismanaged the arbitration and it was a breach of their right to be heard. After hearing the submissions, the Court of Appeal said, first of all, the AEO ruling was not without basis because there was evidence to show that there was danger of misuse of the documents. And the Court of Appeal said that there must be a balance between the contractor's right to prepare for his case and the owner's rights to confidentiality. Now, the contractor's complaint about access to project documents was also without basis, the Court of Appeal found, because the contractor did not request production of these documents in the arbitration. And even his own submission, it shows that they were able to assess the value of his pre-termination works without difficulty. And finally, the Court of Appeal found that there was no basis to impeach the tribunal's decision to allow the owner to continuously disclose documents on his cost because the contractors were given sufficient time to file their response report. And there were important takeaways. First, the Court of Appeal said that the tribunal could not be criticized for not dealing with points that have not been put to it. What do they mean? They mean that during the arbitration hearing itself, the contractor did not raise any complaint about this decision that was made by the tribunal. And the Court of Appeal said that you cannot blame the tribunal for not dealing with your complaint if you did not complain to them. And what that means is that the Court of Appeal said that you cannot wait, okay, and hash your position. And if the arbitration turned out against you, then only you complain. So the rule or the key principle to take away from this is that if a party is of the view that their right to due process have been violated during the arbitration, they must raise the issue with the tribunal there and then. Otherwise, the court will not entertain any complaint after the arbitration is over. Now, the second case that I'm going to look at is the case of CBS. This case concerns sales and purchase of coal. And under the sales and purchase of coal, obviously, there will be a receivable due from the buyer. And this receivable was assigned to a bank under a facility that the bank granted to the seller. And there was an issue that arose out of the second shipment of coal, and the bank commenced arbitration against the buyer for the debt due. And in that arbitration, the tribunal asked if an oral hearing was necessary, because the buyer wanted an oral hearing because they want to present witnesses. The tribunal said, well, let's see your statement first. Put in your witness statements. And once I've read the witness statements, and I will decide whether you should call them in the oral hearing. The buyer refused to do that. The buyer said, I have a right to call my witnesses. Arbitrator then convened a hearing, but not for presentation of witnesses, but for only oral submissions by counsel. The buyer was very unhappy. They withdrew from the participation, and arbitrators found for the bank. The buyer applied to set aside the award on the ground that there had been breach of natural justice. This is what the Court of Appeal said. Now, the arbitration was conducted under the Singapore Chambers of Maritime Arbitration Rules, what is called the Singapore SCMA rules. And 28.1 says that unless the party have agreed on documents-only arbitration, of that no hearing should be held. The tribunal shall hold a hearing for the presentation of evidence by witnesses, including expert witnesses, or for oral submissions. Now, the tribunal thought that these rules allow him to hold a hearing for evidence or for oral submissions, okay, and he has a choice. And the tribunal says, sorry, you got it wrong. 28.1 does not allow you to hold a hearing only for oral submissions. 28.1 says that you must hold a hearing for presentation of evidence if the parties so request. And therefore, the arbitrator's misapprehension of his power resulted in a breach of natural justice, and award was set aside. Now, this is one of those rare cases where award was set aside, because the tribunal made a wrong decision on interpretation of the rules, and therefore there was no issue as to whether the tribunal has a right or not have a right to make those decisions. Actually, they got it wrong, and they have no right whatsoever. And finally, the case of Truizzi Cesare. In this case, there are 3 contracts for the purchase and installation of washing machine. And the dispute arose out of this contract, and arbitration was commenced. The defendant filed an expert report on 1st April, but the plaintiff objected to the expert report on the basis that there was an agreement to dispense with the expert report. The tribunal then admitted the expert report from defendant on 5th April and directed that the plaintiff file the expert report by 15 April 2013. But on 12 April, the plaintiff complained that it did not have enough time. And then on 16 April, the tribunal said it will not vacate the hearing date because of plaintiff's complaint. And the hearing starts on 22nd April. Until the hearing starts, the plaintiff did not file any expert report. And then on the last day of hearing, the plaintiff applied to adduce expert report, and the tribunal rejected the application. And obviously the award was delivered in favor of the defendant, and the plaintiff applied to set aside the award on the ground of breach of natural justice. In this case, the High Court said, first of all, there was no agreement to exclude expert report. It was just a procedural timeline that was issued by the tribunal. Although the timeline did not contain any procedure for expert report, it does not mean that the party have agreed to exclude expert report. So the tribunal could not complain about the timeline given by the tribunal. The plaintiff, could not complain about the timeline given by the tribunal to file its expert reports, because the directions was given after having heard all submissions. And the plaintiff failed to explain the full extent of his needs for expert report, and therefore there was no breach of natural justice, and the tribunal's directions fall within a broad and flexible case management power. Here you can see again, the court actually give a lot of leeway to the tribunal to make their decisions on case management, and the court will not interfere. Okay, even when the tribunal refused to admit expert report, if the request is made very late in the day. Now, Having seen those 3 cases, there are some, I would say, tips or guidelines that are given by the Chief Justice in his lecture to the Chartered Institute of Arbitrators in 2020. He says this is what he says to tribunals. He said that arbitrator tribunals should focus their attention firmly on the task at hand. That means that whatever decision they have to make on the procedural issue, you focus on it, decide based on the information that you have, and as long as you have a reasonable ground for your decision, the court will not interfere. So don't be too fixated with the theoretical risk of enforceability. That means that don't be too fixated with avoiding the risk of having your award set aside. Okay, that should not be what is occupying the tribunal's mind. Then the tribunal should also promptly denounce any dilatory tactics. That means that any guerrilla tactics, any attempt to introduce evidence late in the day without good reasons should be denounced. Denounce is actually a very strong word. That means the tribunal should actually make it very clear that they do not accept such kind of procedures. They do not accept such kind of tactics. Okay, and they will not accommodate this kind of guerrilla warfare. And they will serve as a warning sign to the parties. And the tribunal should set the tone at the very outset to establish an environment that minimizes the likelihood of abusive behavior in the first place. This means effectively at the first procedural hearing, tribunal should set out very clearly their attitude towards guerrilla tactics, and they should convey their expectations to the parties very clearly. And they should use case management functions very effectively. What does that mean? I think the Chief Justice is trying to say this. If you are a tribunal, you should manage the case very closely. There are tribunals that do this, and I've seen this very, very commonly. They'll call a case management conference and issue procedural order number 1, which will be a comprehensive timeline for all the things to be done all the way to hearing. And then after that, the tribunal will forget about the case and will not turn up until the hearing. Now, that is not a very good way of managing an arbitration. And what the Chief Justice is saying is this, that you must keep a close tab of what's happening and have regular case management conference to make sure that the parties are complying and following the procedural timelines. And if they are not, you should analyze and scrutinize the reason for their failure to ensure that nobody is trying to take advantage. And the last thing that Chief Justice said was that the tribunal should actively engage with parties to foster a culture of initiative and diligence and honesty. A culture of initiative, diligence, and honesty. Not honesty, honesty. Okay, so that is the parting shot I'll give you from these recommendations from the Chief Justice, and hopefully with this guide from the court and from the Chief Justice, the harm or the problem that is posed by due process paranoia can be curtailed, and legitimacy and credibility of international arbitration can continue to be achieved and continue to be accepted by parties and by users of international arbitration. Okay, thank you very much. And I'm open to any question that anyone may have.
Okay, thank you very much for your wonderful presentation and very informative. We have learned a lot from your presentation. Now I would like to share the screen first because I would like to ask for your comment as well on the summary of these slides. So actually I just like kind of do my own summary just for some points because you have cover a lot of issues that's super useful as a guideline for all of us here. So I would like to provide a summary and would like to ask for your comment, or if you have any advice from this guidance from the court to either the parties to arbitrations or even for the counsels or even for the arbitrator as well. So from the presentation that given by Jillian, we can see that if we start with the model, the Austral one, the model law, as amended in 2006, you can see that the word used as presented by Gillian as well, used the term full opportunity to present one case. And then the revised version, the rules, as revised in 2010, it changed to the word reasonable opportunity to present one case. So it's kind of different terms. And as the model law can be adopted by some model law country as well. So there are quite different wording that used in the national arbitration law or arbitration act or ordinance. For example, some countries still use the word full, right? Full opportunity to present one case, if I understand correctly, including Singapore, right? And also at the same time, some country, they have changed the word from full opportunity to be the reasonable opportunity. This one could be the case of Australian Arbitration Act, UK, ICC as well. However, as you already pointed out, even though Singapore seems to use the full opportunity to present one case, but there is a super high profile case, which is the case of the Jaguar case that you kindly advise and present a lot of points that very interesting to us as well. Because even though Singapore version used the word full opportunity to present one case, but in the Jaguar case, the Court of Appeal have usually provide a lot of guidance on the issue of due process challenge as well. For example, from some of your presentation, the party's right to be heard is impliedly limited, even if in the act is used the wording full opportunity. But the Court of Appeal in the Jaguar case is said point out that the party's right to be heard is, however, still impliedly limited by the consideration of the reasonableness and fairness, and also subject to a case-by-case analysis or context-specific. And also, the court have to ask itself if what the tribunal did or decide not to do fall within the range. So within the range, it means that could be more than one right answer, right? So the court have to ask itself if what the tribunal did or decided not to do fall within the range of what a reasonable and fair-minded tribunal would have done in those circumstances. And court will offer the margin of difference to the tribunal and will not intervene simply because it might have done things differently. The right of each party to be heard does not mean that the tribunal must sacrifice all the efficiency in order to accommodate unreasonable procedural demand by a party. The alleged breach of natural justice must be brought to the attention. This point, Gillian usually highlight for us, and it could be some advice for lawyers as well. So the alleged breach of natural justice must be brought to the attention of the tribunal at the material time. So you have to, for example, challenge it within the timely manner. So, and also due process challenges were often used as a ground to improperly attack the award. This is in the word of the court, and that is undermines and cheapens the real importance of due process. I also add a little bit of the guidance, judicial guidance from other jurisdictions as well. Very quickly, in Hong Kong, the tribunal conduct has to be serious or egregious before the court will invoke its power to set aside the award for want of due process. In Malaysia, the Malaysia High Court stated that natural justice does not demand that party is entitled to receive responses to all submissions and arguments presented for only the right to be heard is fundamental. And lastly, and very interestingly as well, in Australia, on the issue of the virtual hearings, there is a guidance from the court as well. This time it's the Austrian Supreme Court. Said that the challenges based on allegation of procedural irregularity can only succeed under the Austrian law if the tribunal conduct of the proceeding were to result in serious procedural violation or in permanent and significant disadvantages to a party. So in this case, it's even the case where there is one party objecting to the use of the virtual hearing, but still it has been held by the Austrian Supreme Court that it's not a violation of due process. So given all this judicial guidance, what would be your advice to three stakeholders here? Firstly, the party to arbitrations. Secondly, the counsel. And lastly, arbitrators like you. What would be your advice on this issue of the challenge to the due process? Thank you.
Right. I think thanks very much, Kundidara, for this. I think Grand Pacific is actually a decision that was considered, in fact, in China Machine in Singapore. And as you can see, the outcome is actually very similar, right? In Singapore, in China Machine, Court of Appeal say that the test is what whether the decision fall within a range of decisions that what a fair-minded and reasonable tribunal would do. And the flip side of that, obviously, is that the decision has to be serious and egregious before the court will intervene. That's what it says in Grand Pacific. So unless the tribunal's decision is arbitrary or capricious, that's the word used in China Machine, or serious or egregious, the word used in Grand Pacific, then it will not be set aside. Similarly, in Malaysia, same concept is being embraced. And the basic message from the court is simply that, yes, due process is important, but don't abuse it, okay? Don't abuse it, don't manipulate it. And on that basis, what is my advice to the three category of people that you have mentioned, Kuntidara? I think for the users, of international arbitration, you'll be given your right, fundamental right to be heard. I don't think, frankly, that is something that is to be doubted at all. I don't think any tribunal will knowingly prevent a parties from presenting the case, but you must be clear that your right to present the case, as you say, whether it's full or it's reasonable opportunity, must be balanced with efficiency, with time and cost efficiency, right? So you cannot expect to have unlimited rights to present your case, and don't use what we call tactics such as trying to drown the other side with applications. I've seen a lot of instances where counsel or parties employ technique of attrition. What does that mean? That means that they drown the other side with all sorts of applications, all sorts of interlocutory skirmishes, all sorts of fights, with a view to try to dampen their desire to fight, with a view to drown them in costs because legal costs will go up, with a view to drag out the whole proceedings, okay? And then if the other parties does not have the resources to meet those challenges, then they may end up not being able to put up a fight, or they may end up settling because they don't have the resources to deal with this kind of fight. My advice to them is that the court will not look at those kind of techniques very favorably. Okay, the court has already said this is not the right way to do it. Don't use those techniques. For counsel, the same advice is actually applicable, but more importantly, okay, if you genuinely believe that your client's right to due process has been violated or has been compromised, you must raise the complaint at the material time, as you say. You cannot sit back and say, let's wait and see what happened. If we lose, then we'll complain. If we win, it's okay. You can't do that anymore. Again, the court has made it very clear, okay? You have to be you have to raise the complaint as the first instance, because it's then not fair to blame the tribunal if the tribunal have not heard the complaint and deal with the complaint there and then. And finally, for tribunal, as I said earlier, I think tribunal has to be more, how would say, bold in their decisions in managing an arbitration proceedings. They should not always, like the Court of Appeal say, thinking about, oh, whether my award will be set aside if I don't do this. They should not be thinking about that. They should be thinking looking at the task at hand, look at the decision and give your reasons. As long as you give a good reason for dealing with the decision, even if the court may not agree with it, okay, the court will not interfere. Unless, of course, having to deal with doing something that the rules doesn't allow you to do. Like, for example, in the CBS case, the tribunal did something that the rules did not allow him to do. Then that's a different matter altogether. But if it is within your range of the decision that you're allowed to make, generally the court will not interfere. And actually, I would also take this opportunity to answer one of the questions that have been posed by Kun Amnat that says that can arbitral tribunal assist tribunal so that tribunal can exercise discretion more decisively. Now, it is actually not possible for for the institute to actually interfere or to get involved in the tribunal's decision on procedural matters or on any matters for that matter. Okay, so directly, I think it'll be difficult for an institute to help, but an institution, for example, like SIAC, we actually conduct a lot of courses, we conduct a lot of briefings for our tribunals, for our panel members, to ensure that they know, for example, cases like China Machine, Jago Energy. We do a lot of courses. Every year we have actually the SIAC Academy, where we open up to interested party to come and learn more about how to handle arbitrations, whether as a counsel or as a tribunal. And that's the way we try to disseminate information and to ground our arbitrators with good knowledge of the law and the procedures so that they know what to do when faced with difficult situations. Okay, so that is the answer to Kun Amnat. Okay, before I go with the other question, Kun Didara, you have any other question or comments?
Yeah, actually, I was about to ask you about the tools that can be used by the arbitral tribunal, also techniques or any institutional tools as well that to provide a deterrent for the abuse of the due process. Because I heard that for SIAC, for instance, you have the rule that you have to, I think you pay the fee if you want to challenge something like frivolous claims issues. Do you have any more details about that you have to pay for the fee or something if you want to challenge and you have a kind of the frivolous claim or groundless challenge?
The tribunal actually do have power to order costs against
adverse costs
adverse costs against parties, particularly if the challenge or the application is frivolous. We have power to order costs against the losing party.
Yeah.
So that's one way of doing it. But I think what's more important, and I see as tribunal as well, is to send a message out to the parties right from the beginning that you will not entertain any frivolous applications, right? And if they try their hand on such things, not only will it be met with a serious cost order, okay, it will affect the credibility of their claim.
Yeah, and maybe a good idea to get the agreement of the parties for the procedural orders.
That's right. Yeah.
Maybe we deal with the question on the remote virtual proceedings from Kun Ramin.
Yeah, Kun Ramin. Yeah.
Yeah.
Remote virtual proceedings. Frankly, I've done a number of remote virtual proceedings. I don't think anyone have come out to say that due process has been violated because proceedings were conducted remotely or in a virtual manner. In fact, Singapore courts has been conducting a lot of hearings remotely and virtually. Malaysian courts as well. And I understand even English courts, in fact, courts all over the world has been doing it. So I think anyone who try to say that their due process rights have been violated because proceedings are conducted virtually will really have a very difficult task.
Right.
Right.
Yeah. And there are a lot of guidance as well for many institutions on how to
Yes.
conduct it. And most of the common advice that for the arbitrators who have the kind of the protocol agreed by the parties.
That's right.
That's
right.
Right?
Yes. Yes.
Yes. Maybe one related question to that as well. Because I heard some of the concern about this, because this day, Singapore as well as other countries try to, I think they have a lot of announcement about the lifting or the easing of the restriction on traveling.
Yes.
So would that impact the momentum or the way that the court would approach the use of the virtual hearing in the case where one party is objecting to it? Because before it seemed to be kind of similar to force majeure in a sense.
Yep.
So kind of necessarily and more proportional, more reasonable, right? But what
Yep.
if those impediments have been, get rid of by the government? Would that impact the court analysis on the issue here if there is one party opposing to this virtual hearing?
I've lost my hello, can you hear me now?
Yes, we can hear you.
Sorry, I've lost my speaker just now. Sorry, yeah. Well, I don't think I think the lifting of the restriction of traveling will have an impact because I think particularly for marriage hearing where you have witnesses, tribunal and parties would generally prefer in-person hearing, particularly where you have cross-examination of witnesses. But I can foresee remote and virtual hearing to continue when you have, particularly for case management, you don't need to be in person, particularly if you have parties that span over 2 or 3 or 4 countries. It doesn't make sense for everyone to be traveling just to have a 1-hour case management hearing or 2-hour case management hearing. Virtual and remote also works very well if it's just submission by counsel. But if witnesses are required, then I personally would prefer in-person hearing. So I can see that you have a mix and match kind of situation, depending on I suppose which one is more acceptable. And if I suppose if one party wants a live hearing, it will be more, I think, safer for tribunal, particularly when witnesses are involved, to have an in-person hearing. That's how I would look at it. You're on mute, Kunti Darat.
Thank you for your excellent comment on that. And I think there is one question that specifically addressed to you from your experience from from Moseni. So the question is for you, did you have any challenge to balance the due process? From your experience, did you have any challenge to balance the due process? And how do you deal with that or overcome that?
I think I basically take the recommendations of the Chief Justice, right? And frankly, if you have a tribunal of experienced practitioners, and particularly a lot of us have been counsel before, and we know the tricks up your sleeve, right? And if you try any of those tricks, we will see through it straight away, and we will make the necessary directions. And frankly, if it is a genuine application request to introduce evidence at the last minute, and there is a good reason for it, we will give it. So, like I say, it is a very spec specific, and the challenge, not really the challenge, but the real issue is really to sieve the real situation from the manipulation. And as long as you see there is a manipulation, you should cut it off straight away. If it is a real situation of a party wanting to introduce something late because there's a good reason for it, we will allow it.
Right. So that just mean you might need to give more time to the other party as
Yes.
well to respond,
Yes.
right? Because I
Yes.
found some case where the challenge was that one of the party raised some of the argument at the closing submission.
Yeah.
And I think that the challenge was successful as well on the due process ground.
Right. Right.
Yeah.
So it all depends. Like the chief says, is very spec specific, and at the end of the day is whether a party has good reason for asking for what he's asking.
Yeah. I think I look at the time. Maybe we can have one more question. Would you like to pick one that you think you can answer within the few minutes?
Yeah, I think there's one by James Kwan is actually interesting.
Okay. Right.
He said that there's a situation where a non-participating respondent has not filed a defense and did not participate despite giving opportunities. And on the eve of the hearing, he said he want to instruct lawyers to defend the case. How will you deal with the situation? At the first instance, if it is the first time they're asking to defend the case, I would give them the opportunity to, right? Because it is fairly important that you have the parties appear before you, right, and deal with the case so that you can have a full and holistic view of the issues. So and if there is any delay or cost implication, then obviously that can be taken into account in your award. Okay, but at the first instance, yes, I would give the defendant the opportunity. But if it becomes a regular or repeated tactic, then yes, I will cut them off. Right.
Maybe just because we only have one question left here, why not just deal with one question from Professor Vichai Aryanantaka, the senior judge in China.
Which one is that? Sorry.
From Mr. Vichai Aryanantaka, actually professor.
Okay.
And also the judges, one of the judges.
Yes.
Is it fair to say due process is more generalized, as in generally accepted as due process, regardless of whether it's full or reasonable opportunity? So you think the concept is generalized?
Yes, it is a general concept. In fact, it's enshrined in many constitutions of many countries, right? That nobody should be deprived of their rights without due process, right? So it is a general right and general fundamental rights in country. But in the context of international arbitration, like I say, it gives rise to 4 components. Now, obviously, one of the 4 is where a party should be given the opportunity to defend or to present his case. And unfortunately, different words were used, full or reasonable opportunity. As we have seen in Singapore, there's no really difference between the two. But it is a general right. That means that one has to be treated very fairly before your rights can be compromised or deprived.
Yeah. Okay, I think we deal with all the questions from the audience. So I think now the time is up and we have a lot of great insights coming out from these sessions. Thank you everyone so much for your meaningful contribution, especially our speaker, Yilin, for your excellent presentation and also excellent insights when you answer all the questions from the audience as well. And also thank you our participants for taking part in this lecture from this different part of the world. And we hope that you did have an enjoyable and also insightful session with us. And we do hope also that you will continue to support the future events organized by SIAC and also Chulalongkorn as well. So until next time, please have a wonderful evening and enjoy the rest of your day wherever you are. Thank you very much. ขอบคุณค่ะ
Thank you very much. ขอบคุณครับ Next time, I hope I can be at Chulalongkorn University to deliver the message.
Yes, please.
That would be great.
I did attend the SIAC Academy in 2019 and I met you. I'm so impressed by your lecture as well. Thank you so much.
Thank you very much. Thank you. It's been my privilege and my honor to be able to give this lecture. Thank you.
Thank you, everyone. Have a great evening. สวัสดีค่ะ
สวัสดีครับ